All right. Well, welcome everybody to our first hybrid alumni speaker event of the year for the Willamette MBA Executive Speaker Series. We're excited that we're not all on Zoom this year. We've got some in-person audience, but we're also glad for those of you in virtual land for tuning in. We have joint degree alumnus Tim O'Connell with us, graduate of 1985, which is JD and his MBA. He has worked in labor and employment law at Stoel Rives for over 28 years.
30, well, but it's Stoel Rives for
28 years.
20, yeah.
Okay.
25.
25. Okay. All right. He's also served on various committees, and he brings us a wealth of good information about our topic was a little bit cheeky, but about why it's important to understand policies related to business and how if you don't understand how the sausage is made, you can get into some trouble. Tim's also an undergraduate alum from Whitman College, and while he was there, he was on the debate team, and then while at Willamette, he was also served as an assistant debate coach. So with that, we're excited to host Tim.
Thank you, Patty. Pleasure to be here.
Excuse me, do we have the Zoom link available? I've received some questions from some students. Is the Zoom link available?
We'll email it to you, Karen.
Perfect, thank you. I'm sorry to interrupt.
Oh, no.
Welcome, thank you.
The more the merrier. So if you need to log in, we've all gotten used to the new normal. I'm hoping it's not the new normal. We're just calling it the new of having to deal in the virtual world. So I'm glad that there's some of us here. Laws and Sausages is the title of this talk, and why are we focusing on this? Come at it from two perspectives, because I'm a law and Atkinson grad. I happen to think that if you are working with a business or running a business, we all focus a lot on what comes out of the other Washington, D.C., right? But, unless we get global thermonuclear war or the $75 Big Mac or something in between, most of what impacts you on a day-to-day basis is going to be the things that affect you locally. And from the perspective of operating your business, it is, as often as not, state law that can make the difference between success and failure. And in all of the states that I'm concerned about, mostly the West Coast, I'm admitted to the bar in all three West Coast states, and my firm practices throughout the West. In all of those states, when we talk about what is state law, it means the actions of your state legislature. And so we're going to spend a few minutes talking about how that process actually works, because laws impact business. And one of the things I found is that when something impacts business tries to impact the process. And so we're going to talk about that. Let's correct the historical injustice. The quote that you see at the top, if you like Laws and Sausages, it's better not to watch either one being made, attributed to Bismarck, Reich Chancellor of the Imperial German Empire from 1871 to 1890. There was some really interesting pedagogical work done in 2009 because some scholars observed that you can't find this phrase in any of Bismarck's writings, any of his speeches. In fact, it was only first attributed to him in the 1930s, which is 40 years after he died. And so they go back and they found what really is the genesis of this. And the earliest citation is John Godfrey Saxe, which you see up there. I'm not going to read it. A little different. Actually, I think articulates it a little better. And the reason I prefer that, of course, is if you Google Saxe, Google will identify Saxe as a lawyer poet. Now, that's a great juxtaposition. I like to think some of my written work is poetical, but very few people agree. So, as between a lawyer poet or a guy who subjected Europe to 75 years of bloodshed, I'll go with Saxe. All right. Background. We talked about why the legislative process is important. For those of you who are in the joint degree program, what would your role be if you're coming at it from an attorney perspective, if you're running a business? role is pretty plain, right? In the sausage making, you're the pork, more often than not. So I got to tell you right up front, I'm not a lobbyist. I am a lawyer. But as a lawyer, I advise lobbyists and I advise the businesses who they hire. And I say I'm not a lobbyist because, by golly, I am not going to start filing forms with the Public Disclosure Commission. That is my story and I'm sticking to it. But as someone who advises business, sometimes you get brought in to testify, supposedly. We'll talk about that in a little bit, or advise legislators about the things that they're legislating about. I've been doing labor and employment law for 35 years. And sometimes even when you talk about the legislators who are on the relevant substantive policy committees, and sometimes people who have been on those committees for a long time, one of the first things you learn when you interact with them on a regular basis is how little they know. Legislators are by design kind of like the Platte River. If you're familiar with the Platte River, it is about a mile wide and about 2 inches deep. And that is most legislators. So we're there in an educational sense, not to lobby them. A couple of comments before we get into the merits of some of this. There's a saying that I think this might be a saying that I learned in B school, sure not law school, and that is where you stand depends on where you sit, right? Your position on an issue is very often dictated by where you're coming into that discussion. And so if some of my comments sound a little partisan from time to time, I'm not overly partisan, but on the areas that we're talking about, things tend to fall through certain well-defined lines. And we're going to talk about those lines in the real world. So background for the two case studies we're going to talk about for the next 20 minutes, 15 minutes or so. Washington's 67th legislature first session, why we call it that way. After every election, the composition of the legislature changes. And so as a constitutional sense, each legislature is its own legislature. So we refer to 2020 as the 67th legislature. They have two sessions in the state of Washington constitutionally. The first session of the legislature is 90 days. The second session of the legislature, again, starting in January of the following year, is 60 days. It is a part-time legislature. After the 2020 election, the 67th legislature had firm Democrat majorities. Now, notice the breakdown, because 2020 election had been a bad year for Republicans in the state of Washington. Democrats had a firm majority, but that is not a supermajority. That's an important thing to keep in mind. For some actions under our state constitution, you need 2/3. That's not 2/3. For some actions, you need 60%. Notice both of those majorities fall just short of 60%. So that's important to keep in mind. In 2020, there was a lot of what I call pent-up demand, and that is pent-up demand from the people who turned to the legislature seeking to get stuff. The other side, because like I say, my clients are the pork and they want more sausage. There was pent-up demand because for 6 years prior to that, the state Senate had been controlled by what's referred to as the majority coalition. It was 24 Republicans and one conservative Democrat who caucused with the Republicans to give the Republicans the working control of the state Senate. As a result, for that 6-year time span, much of the pent-up demand from some of the advocates was, well, pent up. They didn't get very far. In the first session after that change, there was a by-election. We had kind of a reprieve in that sense, because you may recall something that happened in March of 2020. It kind of derailed everything. So the 2021 session, because that's what we were really talking about, right? The election was in 20, legislature seated in January. The 2021 session was the second Zoom session. Everybody was pretty used to dealing remotely, for good or for ill. The place where you have most of these disputes, because I'm a labor lawyer, so our two case studies are going to be both labor and employment statutes. In the state House, it's the Labor and Workplace Standards, LAWS, called the Laws Committee. That gets confusing. But in the Laws Committee, Chairman Mike Sells, pretty good guy. He's a pretty old-line Democrat and easy to work with. Ranking Chair, Representative Hoff, out of Eastern Washington. You notice how split that committee is, notwithstanding the facts that the Ds have a strong majority in the legislature as a whole. When you do the math, it still works out to that kind of a breakdown, 4-3. The Senate Labor, Commerce, and Tribal Affairs Committee, chaired by Senator Karen Kaiser. Senator Kaiser, longtime chair of that committee. She is something of a more left of center Democrat. Her day job is she is a union business agent. And so she comes at things from that perspective. Senator Curtis King will actually play a role in one of the bills we're going to talk about in a moment. Again, a fairly closely split committee. The interesting thing about the Senate Labor and Commerce Committee is its membership doesn't really reflect the overall membership of the Senate Democrats. Senate Democrats, there are still a few moderate Democrats in the Senate as a whole. There aren't on the Labor and Commerce Committee. That's a pretty well-controlled committee. It's important to know who the chairs are. Here's one of the first things to remember, at least in the Washington legislature. If the chair doesn't like your bill, it's going nowhere. The chair has the ability to schedule hearings. It's at the discretion of the chair. And if the chair doesn't like the bill, that's the first way the chair kills it, is you don't even come up for a hearing. There's lots of times when bills that really have no significant chance of passing the legislature will be given a courtesy hearing anyway, as a courtesy or favor for the sponsor. But it doesn't work the other way. If the chair doesn't like your bill, he's not going to give you the courtesy of a hearing. One of the things that flows out of the fact that it's a part-time legislature is that time is our most precious resource. The thing you see up on the slide is actually a cut and paste right out of the legislature's website. Notice there's a few blanks on there, which I did on purpose. There's special time cutoffs for fiscal related bills, bills relating to passing the budget, that type of thing. So because neither of the bills we're going to talk about were related to the budget, I just eliminated that. These cutoffs are really hard in the sense that it's not easy to get an exception to that. So if the House of Origin, so the first bill we're going to talk about is a Senate bill. So the Senate was the House of Origin. The bill's got to pass out of that House by the March 9 date. If it doesn't, it's dead. Regardless of its merits, if it doesn't meet that cutoff, it's dead. And the similar cutoffs as you go through. Note in the next to last line there, the April 11 is really the magic day for a bill to pass out. Notice that one little caveat there. Matters necessary to implement the budget. Okay, what does that mean? Well, any matter that's going to have any kind of financial impact could be deemed by leadership a matter that affects the budget. And that's significant. Washington is always revenue constrained, and so those bills can get a little bit of leeway. So, our first bill, ESSB 5172. Yes, sir.
Before you get too far in, I was just curious, when you're preparing for a legislative session and you have your objectives in mind, are you building out a strategy ahead of time, or is it more that you have the principles that you're going to talk about and you deal with the issues as they come up?
Yes. Yes, both is the quick answer. One of the things about the legislature is it's not like a civil trial, right? If you have any familiarity with litigation process, you know that a civil trial is typically preceded by anywhere from Some courts is as little as 9 months. Most courts, it's 18 months. Bigger cases, it might be longer. A year, sometimes more, of what's referred to as pretrial discovery, right? We don't like trial by ambush. The Washington legislature loves trial by ambush. We don't have pre-hearing discovery. We don't know necessarily what the other side's going to be up to. I say necessarily. In fact, we've all been doing this for a lot of years. We have a feel for what's going to be motivating them. More often than not, and the second bill that we're going to talk about is an example of this, it's not at all uncommon for a bill to be considered in multiple legislatures because it needs a certain amount of time to get traction and for people to be convinced and for people to give it the priority that it needs. Every year the legislators that make up the Washington legislature introduce somewhere between 4,500 and 5,500 bills. Every year, less than 1,000 are enacted. So if you want to seriously get a bill moving forward, it's got to have some kind of priority with enough legislators for that to make a difference. So we know what those are. Big picture, we are advancing general principles because there's lots of times when things are a surprise. In a very real sense, we'll talk about in a moment. The first bill we're talking about, 5172, very much was a surprise, and we'll talk about why in a moment. And in those cases, you're just left to respond on the fly. That's part of the gig. I have been, Patty mentioned I've been doing this. Most of my work comes from my connection with the Association for Washington Business. AWB it's a combination organization. Most states has a state chamber of commerce, and then also there's separately the affiliate of the National Association of Manufacturers. AWB is both. It's both the state chamber of commerce and the manufacturers representative. So it's probably the preeminent business side political actor down in Olympia. And I've been active with AWB for a number of years. I was the chair of its employment law committee for 2 terms. And then after finishing at the employment law committee, I was named as the chair of AWB's overall legal affairs committee. And I did that for 2 terms, and then my second term was extended. Point being, I've gotten down to Olympia a lot for those guys. And so it's, the legislators know me, and that's helpful. It's an example of the power imbalance. As I said, Chairman Sells has been the chairman of the House Laws Committee for a number of years. When we're in his office, he's Mike, I'm Tim. When we're in the hearing room, I'm Tim, he's Chairman Sells. So there's a lot of both planning, but also just being responsive. So ESSB 5172, here's your first inside tip. ESSB means something. That means it's the engrossed second substitute bill. Senate bill, SB, substitute means at some point in the process, someone made an amendment that for all practical purposes eliminated the predecessor bill entirely and put in a substitute bill. Engrossed means that even that substitute bill was amended on the floor at some point. And that's the process we went through here. So remember I said at the beginning, state law can have the most direct impact on your business. 5172 addressed a situation that was in all likelihood going to bankrupt most Washington agriculture. Background on that. 1936, the Fair Labor Standards Act. That's the federal law that mandates a minimum wage and overtime for working more than 40 hours in a week. From the first days that that bill was enacted, was even proposed, it exempted farm workers. And, the rationale for that, at least back in the 30s, many farm workers were not paid cash, but were paid in kind. And moreover, everybody recognizes that farm work is uniquely seasonal, right? You'll have months where there's virtually nothing to do and months when you're very, very busy. So because of that, it was always believed that the 40-hour work week week in and week out didn't fit the agriculture model. So farm workers were excluded from the Fair Labor Standards Act. 1959, Washington passed its own Minimum Wage Act. The FLSA, Fair Labor Standards Act, the FLSA is maybe not unique, but it's one of a very few set of federal laws that has an anti-preemption provision. Okay? Preemption, the notion that under the Supremacy Clause in the Constitution, any federal law trumpets any state or local law. Well, the FLSA has an anti-preemption provision. The states, not municipalities, but states are allowed to enact laws about overtime, about minimum wage that are more protective of employees. So it's easiest to think of in the context of the minimum wage. Federal minimum wage is $7.25. Can't go below that. States can enact a minimum wage higher than that. Both Oregon and Washington have. So we enacted in the state of Washington, we enacted our Minimum Wage Act 1959, and like the federal FLSA, it excluded farm workers. 1988, by initiative, notice it's by initiative, it's not by action of the legislature. The voters of the state of Washington extended minimum wage protections to farm workers, but they consciously did not enact overtime for farm workers. In 2020, actually a case that started in 2019, Martinez Cuevas versus DeRuyter Brothers Dairy, in a narrow, fractured 5-4, it's actually 2-3-4 decision. The Washington State Supreme Court declared the exclusion of farm workers from overtime protections to be unconstitutional. They reached that conclusion by looking at Washington has what's referred to as a privileges and immunities clause. It's actually broader than the federal equal protection clause. And the majority concluded that the farm worker overtime exemption violated that provision. I won't get into that in too much more detail, other than to say they're wrong. I say that because I argued the case to the state Supreme Court. You read the fractured decision, and it's very apparent that the dissent was originally drafted as the majority, because it's much longer than the majority, and it's much more thorough dealing with the issues. And the majority kind of was plainly what was going to be a dissent, and somebody changed, because the dissent is much shorter, is much more cursory, and it's wrong. But on the other hand, I'm not on the court, so I don't get to say. But it created this situation, and here's the real problem. The DeRuyters ran a dairy. The plaintiffs in the DeRuyters were the milkers, and milkers work lots of hours, because I don't know who here has any experience with dairy cows. They don't take Sundays off. They don't take holidays off. The cows have got to be milked 3 times a day, 365. The DeRuyter decision from the state Supreme Court handed down, coincidentally, the Thursday after the 2020 election, so November 8th, whatever that was. Not coincidental, but the DeRuyter decision left a couple of big questions really wide open. The plaintiffs in the DeRuyter case made a real big showing based on the kind of work that these milkers did, almost factory-like, right? You got to get in there, you're milking the cows, and it's the same cows day in and day out, not very seasonal, right? So you had a whole set of issues arising from that. The other issue was that they expressly left open was whether they were going to give this case retroactive application. I mean, there's no question that they are overturning a statute that by its terms explicitly excluded these folks from overtime. And that just raises in a lot of people's mind just a basic fairness issue. You have unquestionably been following the law. It's been the law since anyone in this room was alive. And how can you be held liable to someone for pay? Because that's the issue. It's back pay for overtime. Under Washington law, you go back 3 years plus prejudgment interest. And most farms in the state of Washington, and for that matter, everywhere, just because something is rural doesn't mean it's poor. But most farms don't have those kinds of margins, that they have literally millions of dollars just sitting around in a kitty somewhere. And that's the amount of money you're talking about, because you talk about every employee, you figure out how many hours each week they work in excess of 40. You take whatever they were paid, you divide it by the amount of time, there's the hourly rate, increase that by 50% and write on a check. Statewide, hundreds of millions of dollars. Yes, sir.
How many years back were they, if the back pay was to be applied, how many years back are they looking to apply it to?
3 years.
Okay.
Statute of limitations for this kind of a case under Washington law. It's different from federal law, different in Oregon. But Washington law is 3 years. You get to go back 3 years from whenever you filed the complaint. Okay. So it's 3 years of back overtime liability. And, like I said, I didn't like the decision. We filed a motion for reconsideration because there were, as I say, the dissent that became the majority didn't deal with some issues. We said, you got to deal with these issues. They didn't care. So we had these two great big questions. And literally within the 2.5 months after the DeRuyter decision came down, there were dozens of copycat lawsuits filed against farms in the state of Washington seeking back pay, retroactive back pay for all of that overtime work. When I'm talking about bankrupting Washington agriculture, that really was the issue. There's some, I don't do bankruptcy work. Thank goodness. I have partners who do bankruptcy work. I know other lawyers who do bankruptcy work. And from about mid-November until April, when we got this bill passed, they were really busy helping their soon-to-be ex-farmer clients find a way to protect their assets. It was an issue. Now, the interesting thing is, I saw some heads nodding when I talked about, is it fair to impose 3 years worth of liability on someone who was plainly following the law? At a certain level, that was a bit of overreach on the part of the state Supreme Court, because pretty quickly the ag industry, my clients, came up with a compromise to put before the legislature. I mean, here's the deal. One of the issues that's outstanding after the DeRuyter case is, does this apply to people other than milkers? What about folks who are planting crops, plainly very seasonal kind of work? The other issue, of course, is the retroactivity. So the deal is, we'll agree. We will have farm workers covered by overtime, but let's phase it in over time and not go straight to a 40-hour work week. You need some time to adjust your production methods, but we'll get there. From a business perspective, it's 6 of one, half a dozen of another, right? I mean, everyone in this room can do the math of paying someone X for 50 hours a week, as opposed to some percentage of X for 40 hours a week and a higher percentage of X for the other 10 hours of overtime, and come out to the same number, right? That's not complicated math. You can do that prospectively. You can't do it retroactively. And so that was the compromise. We'll phase it in, we'll extend it to everybody, but eliminate the retroactivity. Senator King, who I mentioned a few moments ago, was a prime sponsor of the bill. We worked very closely with him. I actually drafted the retroactivity section in this. And so it's going to get it done. It was introduced in January. We had a hearing on the 28th. For those of you who are on the law side of the MBA program, let me assure you that when we use the word hearing in the legislative context, it's a hearing in the same sense that Stalin's show trials were trials. You're given typically 3 minutes. There's a little light. When the light blinks red, the chairman will say, "Thank you, let's move on." The only exception to that is when you've actually struck a chord, then they'll start talking to you. And that happens. That happens. That's when it's the Chairman Sells calls me Tim, and I call him Chairman Sells. That does happen. But more often than not, those hearings, it makes my teeth hurt how much I want to cross-examine some of the people who are saying some things in those, quote hearings, close quotes. But it's part of the process. This is in the Senate, so is Chair Kaiser. Chair Kaiser came up with this kind of goofy amendment to the original clean bill. That's where you got the substitute in 5172. That would have created this fund where farmers would have paid L&I, and L&I, Department of Labor and Industries in Washington, L&I would have gone out and tried to find farm workers and write them checks and sprinkle L&I dust over things and make it better. Rube Goldberg was the only person who would have liked that kind of a process. It did pass out of the Senate. It was amended in the House to get rid of Senator Kaiser's Goldberg approach, get back to the straightforward phase-in that we discussed, and passed. I think the telling thing is to look at the numbers for both chambers. This was a bipartisan effort. And I think it was bipartisan because, as I said, I think the state Supreme Court overreached. It's just not hard to figure out how unfair it is to put people in bankruptcy for having followed the law. And so we got the bill through the process. Governor signed it. One of the interesting things, Governor Inslee had kept his cards very close to his vest on where he was on this bill. So when I say we amended it in the House, one of the things we amended is that the bill has now got 4 sections that have very little substance to them. One big section that encompasses every component of the deal, and then some other sections to implement it. Why do you do that? Well, you do that so the governor can't veto the darn thing. Because in Washington, the governor has a section veto. Washington is not like some states where the governor can veto individual words. He's got to either veto the entire section or none. So we did it that way to preclude a gubernatorial veto. Success, bipartisan success. All right, conversely, second substitute House Bill 1076. You now know what those letters mean in front of the HB, right? Second substitute. Again, second substitute means there's a lot of work going on in the process. This is sometimes referred to as a key TAM legislation, or coming out of California, the PAGA, Private Attorney General's Act. This is the one that has business lawyers waking up in a cold sweat. It is part and parcel of that pent-up demand. A lot of union activists, activists for various causes, academics, see all kinds of advantages to this. One of the interesting things is that when this was considered in a prior legislature, remember I mentioned sometimes it takes years to get traction. When this was considered in prior legislatures, it had been considered in the judiciary committees because it really is impacting remedies for violations of law. Leadership jerked it out of the judicial committees and transferred them to the labor committees. Why? Well, the statute is pretty darn anathema to most business. It would organize bounty hunters. For those of you who are law students, you know one of the classic things we say that you need to maintain an action is that you've got a fundamental, whatever the legal right you're asserting, but you've got damages. This would do away with it. This statute would allow anyone alleging a violation of a number of Washington's employment law statutes to sue, even if they are not impacted by the violation at all. They don't have to have any damages. They just got to assert that someone has damages. Yes, sir.
That sounds familiar to something that Texas is trying on a different issue.
The irony is not lost on me because the folks who are in favor of the one are against the other, right? Yeah, like I say, the irony is not lost on me about that. Maybe that will make some people rethink this notion about deputizing anybody who thinks they can make a nickel to go sue anybody with whom they don't really have a dispute. That's just one of our concerns about it, obviously. It's based on a California statute. That statute was enacted by the PAGA, Private Attorney General's Act, That statute was enacted by California in the late 70s in response to some budget problems they had. And they asserted that the Attorney General's office was just so understaffed they couldn't police their own laws. That statute is a nightmare. It is complicated doing business in California immensely. There is currently pending a fairly significant challenge to the constitutionality of it. When we were debating the bill, I testified that I think it's got some constitutional problems under Washington law. But on this one, it's no compromise. We just can't live with it. There's no way you can fix it. This screenshot you got up there is actually the first page of an article that appeared in Bloomberg Daily Labor Report. I was interviewed in this. You'll see the quote at the bottom paragraph there is of me. I actually thought the reporter who interviewed me about this had forgotten about it because the article didn't run for about 2 months after I got interviewed. Because Bloomberg, I just want to say this again without being overly partisan. There's a reason Michael Bloomberg ran for president on the Democrat side, right? Bloomberg News reflects that. The news reporter who interviewed me was actually quite, I think, honestly confused because the thrust of his question was, okay, California blazed the path with the PAGA statute 20 years ago. How come no other state has enacted anything along those lines? Even all these blue states like Washington or New York or New Jersey. Why hasn't any one of them gone down this road? Well, and the answer I gave there is the same answer I would give today. California demonstrated what a nightmare it is. It's going to be opposed anywhere and everywhere. So what do you do? What do you do when there's no compromise to be had? Well, make sure everybody's on board, a broad coalition. For 1076, we had weekly strategy meetings with as broad a coalition of business groups as I've been involved with, and I've been doing this for 25 plus years. You have to make sure the legislatures understand. Lots of times they don't. It's easy to posture this bill as just being another enforcement mechanism for laws that are already on the books, which at a certain level, that's what they try to do, right? We have to pay somebody minimum wage. If we don't pay them minimum wage, they can sue. So why is it a bad thing that a professional plaintiff's class can sue instead? Well, it's a really bad thing. And a number of issues along those lines. You have to make them understand. You got to fight everywhere. And this bill was opposed vigorously at every step in the process. And I think that's what ended up getting us to the result we got. And then use the most precious resource. They only have 90 days in the long sessions, and we're going to take up as many of them as we can. Second substitute. Notice how contentious this bill is. In the course of getting through the House of origin, the House that had considered this bill, 3 previous legislatures, it still was substantially amended through the process. Then it went to the Senate Labor Committee, passed out of that committee. As I say, that committee does not have any of the moderate Democrats in it that were the real focus of our efforts. And then it was sent to the Ways and Means. Why? Well, because it was going to create a fairly substantial financial liability for the state. The state could be sued. Now, of course, that they kind of poo-poo. But the other issue is it creates all kinds of investigative obligations on the part of various state agencies. So we demanded, and they had to go through the analysis of what's referred to as a fiscal note. And the fiscal note means this bill is going to have an impact on the budget. Now, it wasn't huge. It was only $15 million. Remember Everett Dirksen's line, right? $1 million here, $1 million there. Pretty soon you're talking about real money. This is not real money, but it's enough money that they had to do a fiscal note. So it had to go to the Ways and Means Committee, which is more reflective of the general composition of the state Senate. Note the date, April 2. It's already getting late in the process. And when the bill was noted for what's referred to as executive action That's when the members of a committee actually go through the bill, mark it up if they're going to make amendments, and pass it and refer it on to the floor of their body. We came up with 23 amendments. What does that mean? That means on a bill of importance where we're going to insist those amendments be heard, the executive session for that would have probably taken about 2 days. Because you're going to go through every amendment. Every member has the right to express their views on the amendment. All of those were substantive, meaningful amendments. All of them were different. Would have taken the committee about 2 days. And when they had noted it for consideration, guess what? They didn't have 2 days to spend on one bill. So it wasn't considered, and as a result was returned to the House unenacted. From our perspective, that's the result we wanted. That does not mean it's done. Remember what I said at the beginning? That was just the first session. There's another session to go. By returning it to the House, it will start at that process. The full House will have to repass it and send it back to the Senate. So this is kind of a stay tuned. So both of those bills, major impact on businesses in the state of Washington. Both of them, a lot of interaction between the businesses and the lawyers getting to the results we talked about. That's pretty much all my prepared remarks. I would love to get any questions if there are any, either from Zoom or here in the room. Yes, sir.
I have a question about the process of going to multiple committees. How does your strategy for trying to sell the bill to different committees shift as you go on the process?
Great question. Great question. The one you see for 5172 is kind of the normal progression. For bills that have a financial impact, they are typically considered by the Substantive Policy Committee first, and then referred to the Revenue Committee, the Budget Committee. I need to be precise. There's a separate Budget Committee, the Revenue Committee, Ways and Means of the Senate. So that's the normal progression. And you're absolutely right. You have different strategies for different committees. Frankly, I mean, again, we're just talking Atkinson people to Atkinson people, right? The Senate Labor Committee, because of its composition, is not the primary place to fight a bill like this, right? We're going to fight it everywhere, but we're going to pick where we expend our resources. And because of the composition of the Senate Labor Committee, it's the passage of 1076 was pretty much a foregone conclusion. Okay, Senator Kaiser, I said her day job is she's a union business rep. The other three Ds on that committee, a couple of two Seattle liberals, and then one who is a I frankly forget his day job, but point being, we know we're going to lose. So yes, you make the points, you make the policy points, because at a certain level, all of this depends on policy, right? But then in the Ways and Means Committee, you make those policy arguments all over again in front of a body that's a little more receptive to them, as well as the financial impact. So the good thing about working with professionals is we know who we're talking to, right? I mean, there's 7 members on the Senate Labor Committee. The Ways and Means is bigger, 15, I think it's 15. But nonetheless, we know who they are, right? We know what their issues are. We know what they're concerned about. We will tailor our conversation, Working with the legislature, one of the rules is you never fib, right? It just doesn't work. You never fib. But you clearly have got to find different things to emphasize to different people. And so you tailor your message to who your audience is, always. Great question. Anyone else? No? Yes, sir.
How has your interaction been with, I guess you could say, the more professional staff? Because you have the political end, but you have the people who are day-to-day public policy, just staff people. Mm-hmm. How has that been for you relating to them?
Well, that's a great question, and let's kind of get down on the weeds on it. most of the professional staff, there's two kinds of professional staff. There are the professional staff who are members of the committee staff. And so they are committee staff. Supposedly they are nonpartisan. And then each of the caucuses, both the Democrat caucus and the Republican caucus, have staffers who are assigned to each committee. But they are partisan staff. Mm-hmm. And so you deal with each of them differently. The partisan staff very much is a representative of either the chair or the ranking minority member. And so we deal with them a lot. The professional staff, by and by, the professional staff take their notion of being nonpartisan pretty seriously. But having said that, they nonetheless, let's go back to the first slide. They can count noses, right? They know who's controlling the committee, and they know the policy that is being prescribed by the folks who run the committee. So, they're implementing those policy directives, which, they should, right? Back when there was the majority coalition running the state Senate, I'm thinking back, some of the committee staff changed when the D's took over, but not all of them. So, they take their nonpartisan job seriously. I guarantee you, remember one of my comments at the very beginning, it is always impressive how little the legislators know. It is their job, it is the committee staff's job to help educate them. And so that's one of the things we work with, is making sure that the committee staff understands the laws that they're talking about. And a few things irritate me more than when committee staff brief the legislators and they get some of it wrong. We'll let them know that. It's a great question.
The two questions I had were around, this is something that you've done for years. You really enmeshed in the different groups that are interacting on these topics and with the legislature. How does someone, if they have a business, but they're not as enmeshed as you are, stay on top of these issues or be mindful of what could be coming, how they can stay informed? And then conversely, if someone's really interested in this kind of work, are there ways to, learn some of those skills, expand your toolbox and such?
Great question. What's the old saying about when's the best time to plant a tree?
Yeah.
The two best times are 20 years ago and today, right? And so at a certain level, my work here grows out of the fact that I've been working with the association for, probably closer to 30 years than 20. But there's always room for more. And B, you've got to start at some point. From a business perspective, it's probably not a shock to anyone here, but in the state of Washington, Boeing's got a very large lobbying staff. I hope I'm not bursting anybody's bubble with my cynicism here. Most businesses are not the size of Boeing. Most businesses will have a difficult time justifying hiring their own lobbyist, right? So a really good way is by becoming a member of whatever business association is more affiliated with your industry, because there's lots of them. As I say, AWB is probably the first among equals and an Olympia, but there's lots of others. The wineries, right? We were talking about wineries a little earlier and how they've changed some of the communities in Washington. The Washington Grape Growers Association is people listen when they talk because they know what they're talking about. And that's the thing about a lobbyist. You're not, people have this view that the lobbyists actually walk the marble halls with backpacks that are full of cash, right? And that's the whole point about why they're walking up and down the halls. The most precious resource they have is knowledge. Because if someone is talking about legislation that impacts some of their constituents, the representatives of those businesses know the impacts. And again, this is why, I forget who I said it to, you never ever fib, because your credibility is critical, because the real coin you have to deal with is knowledge about what the real world impacts are of the folks that are talking. So if you're running a business and you think Washington is doing something that could impact you, get involved through finding one of the associations that's similar with your industry. As I say, there's lots of them. On the agricultural side, there's like 3 main ones. I represented all of them in the DeRuyter case because they allied, because it's all the same set of issues. So in ag, Farm Bureau or the Dairy Federation for the DeRuyters. So there's all kinds of those associations. And, the other thing to do is actually get active. Now, in the legislature, it's really true. Numbers speak. I'll tell you this is a true story from 2 legislatures. No, excuse me, 1 legislature ago, 3 sessions ago. Senator Kaiser, I really like Senator Kaiser personally, but her views and mine don't square up. But Senator Kaiser, as a union business rep, one of the things that unions don't like are the widespread use of independent contractors, right? Are you all familiar with that issue that, the unions think all of those folks should be employees, by God. Senator Kaiser was introducing a bill that would have dramatically impacted the ability to operate as an independent contractor. And one of the things it specifically targeted were hairdressers. Now, as you can probably tell, I don't go to the hairdresser very often. Some people do. Hairdressers, apparently, it is the most common business model for hairdressers, is that individual hairdressers rent a chair from a salon owner. That's apparently like the most common business model, and the hairdressers love it. And Senator Kaiser, deeply believes that people shouldn't be allowed to be independent contractors. So that was specifically targeted in her bill. And God bless them, the word got out. We go to these hearings, and ordinarily it's me and a few other people from the business community. It's a bunch of union folks. The hearing on Senator Kaiser's hairdresser bill was packed. It was packed with all of these very well-coiffed women who were gonna have their say. And it was kind of surprising. And they stayed organized. There's this wonderful, wonderful T-shirt that they printed up. And it was a black T-shirt with gold letters. And it said, I'm going to make up the bill numbers because I don't remember, but it said, no on 1025, no on the companion bill, no on the companion bill, and these bright gold letters on black shirts. And you would see those shirts the whole session. They didn't let up. For 2 years, you could scare Senator Kaiser by coming up behind her and going, snip. Activism works. Activism works. Any other questions? Anybody?
We're kind of at the end here. We just have a couple minutes. So was there a final question, and then we'll close up?
I can shift one to the side if you have a few seconds to talk about the Domzinger case and the ruling on that and how I think it's going to affect. But I was just going to ask how the recent news of 168 plus judges at the moment, showing proof of them having crossed the line and having $100,000 to $500,000 invested in a company, how you see that as an employment lawyer shake out in the next few years. And potentially, if you've seen anything shake out prior, Boeing, maybe in the state of Washington.
I don't know about the Dozinger case, anything other than what I read in the paper, so I really don't have a lot of comments about that.
Okay.
As far as judges having investments, there are standard rules about that. When recusal is proper and when it is required. So it's, once you start talking about 100 and some odd judges, most judges take their jobs very, very seriously. For most judges, that's the terminal job. right? That's the cap of their career. There's exceptions, but most times there's not somewhere else to go to that other than retirement. So they take it very seriously, and I'm conscious of the fact they do take it seriously because I have had judges recuse themselves, given who the defendant or plaintiff is in front of. Anytime you start hearing reports about hundreds of judges who are violating their obligations under the judicial canons, that's something to take note of. I wouldn't be surprised if there's less there than meets the eye. I just don't. You can't evaluate 168 cases just to face it.
So with that, and knowing that we're right at time, is there any final thoughts you have to share with us here and everyone else?
Just that the legislative process is part of the practice of law, and it is part of how businesses operate in our society. And as a consequence, you've got to take it seriously. You ignore it at your peril.
Thank you so much.